I work at the International Criminal Tribunal for the former Yugoslavia, and for many of you, you'll remember the conflict in the former Yugoslavia in 1991, beginning in 1991 through till 1995, and the conflict in Kosovo in 1999, where there were NATO airstrikes into Serbia. The Security Council in 1993, in the midst of the conflict, decided to pass a resolution which created, under Chapter 7 of the Charter, an International Criminal Tribunal. Now, this was quite unique, and it very soon followed by 1994 by the International Criminal Tribunal for the events that occurred in Rwanda. But it was the beginning of a very unique opportunity, some would say one that was doomed to fail, and which had some difficulties in gaining support at the beginning. Now we have the opposite problem. We're full scale, and they're asking us to close down. We find ourselves essentially in a position where we're the busiest that we've ever been in prosecuting cases, and we are in the middle of closing down our institution. Since 1993, there have been 161 persons who have been indicted. There are approximately 26 remaining to be prosecuted, some in trial, some in pre-trial, and we have 2 fugitives that are still at large that we are attempting to take steps with the assistance of a number of states to capture. There's 7 cases in trial, and for those of you who are not familiar with the tribunals, these are big cases. The teams are made up of prosecutors, investigators, analysts, language assistants, specialists in the area of leadership research teams, military analysts, lead counsel, policy advisors, and for quite a long time we had a sexual assault team when we were carrying out our investigations. The 7 remaining trials are expected to take another 2 to 3 years, and then after that, of course, they will have the right to appeal. There's 3 cases that are in the pre-trial stage, and one is the case of Karadzic. You may have heard of Radovan Karadzic, who was at large for 13 years. He was recently arrested about a year ago in Serbia, practicing as an alternative medical doctor under the name Dr. Davic, and was arrested by the Serbian authorities and brought to The Hague. He raises one of the issues that we face, which seems to be a bit prevalent in international criminal justice, which is self-represented accused. Mr. Karadzic, Dr. Karadzic, as he is a psychologist, psychiatrist, has indicated his desire to represent himself. The same occurred with Milosevic. The same occurs with the accused gentleman by the name of Shechel. It's difficult to deal with the circumstances, to meet deadlines, to try and actually enter into negotiations with the defense counsel to see whether they'll admit any facts. It's a little difficult, as you can imagine, to sit down in a room with Dr. Karadzic and ask him whether he'd admit that there was ethnic cleansing in the region over which he had political control. So far, we haven't had too much luck in negotiating with the defense counsel on the other side, being self-represented accused, narrowing the case and focusing the case on the issues that we think, and we would think that a defense counsel would agree are the most important issues. That leads us to the point where the cases remain large. The Karadzic case is expected to take 2.5 to 3 years. And we're doing that at a time where, unfortunately, we're losing staff. Also, in the context of our cases, there was something mentioned earlier, and also by Professor Sadat, that I think is extremely relevant, and it makes one wonder a lot about the work that we do. On the one hand, you're required to investigate and prosecute only the most senior persons responsible for crimes, and you're required to do it in a relatively limited period of time. Now, the United Nations, the Security Council, and the judges have all been very accommodating. They recognize the difficulty in doing these cases. But you have, on the one hand, the pressure, and sometimes even the guilt that you're not prosecuting all those persons who commit the crimes. You have to prosecute the most high-ranking, the most visible, the Karadzic's and the Mladic's for our criminal tribunal. But you have to do that in the context of a recognition that the victims that you bring forward crime-based victims that you bring forward that are expected to testify may not even know of or have heard of some sort. Talking about sexual assault, you have a real, trying to put in context of some of the issues that were raised today, you have a real tension between wanting to bring in the people who commit the physical crimes, and of course many of the people who suffered from physical crimes, especially sexual assault, sometimes don't want to come and testify or don't want to. Others very much want to come and confront the persons who commit the crime, with the tension to ensure that you only prosecute the most high-ranking. Now, at this stage of our tribunal, when we're about 2 or 3 years away from closing, we have no choice but to stay with the prosecutions of the most high-ranking and the people that have already been indicted. We have to do so in an expeditious period of time with the resources we have. And in many cases, we don't even bring the victims or witnesses anymore because the system has now moved into a system where you can actually bring written testimony and file the written testimony. It's a very interesting stage that we're at, and we're merging both civil law concepts, common law concepts, criminal law from various jurisdictions, and doing so when many of our staff are leaving because they have to think of their lives and have to find another place to work when we close down. But what we do have is a very dedicated staff, I think, that will get us through the next 3 or 4 years, and that hopefully after, we started in 1993, so justice is slow, as you can see, but hopefully by the end of our mandate, which may be in about another 3 or 4 years, we will have hopefully captured a number of the crimes that took place in the former Yugoslavia and developed some of the law. Just a few final comments about sexual violence, and we'll talk a bit more about it this afternoon. But in terms of the cases that we have, about half of the cases that remain in our tribunal include crimes of sexual violence. And as you may very well be aware, there's no specific articulation in many of the documents as to what sexual violence is. There's rape, of course, and then there's other crimes, cruel and inhumane treatment, outrages upon personal dignity. And what has happened, and at least what we feel there's been some positive development over the last number of years, is the development of a recognition of sexual violence through the crimes that are listed in the statute. There's lots of room for improvement in my view. But certainly there has been a recognition of sexual violence as a crime committed in war. And in the approximately 16 or 15 cases that remain, half of the persons charged are charged with sexual violence. And these are the senior, high-ranking officials. So sexual violence is not charged, certainly should never been charged, but is not charged now, and is not thought of as a crime committed only by persons who are the physical perpetrators, the ones who commit the crime. Crimes of sexual violence are leadership crimes, and they are attributable to the persons at the highest level, even if they are not involved or not present. And secondly, sexual violence crimes has now been recognized and are charged in the remaining cases that we have as part of an integral criminal campaign. They're not separate, isolated incidents. They are actually events and crimes that are committed for the purposes of achieving particular criminal goals. The tribunal will be finishing its trials. The Yugoslav tribunal will be finishing its trials probably within the next 2 to 3 years. It may be certainly after my dear colleague from Sierra Leone finishes, and we may even take longer than our dear colleagues from the Rwanda tribunal, but hopefully